Hello, everybody, and welcome to the Fearless Floyd Show. I am your host, as always, Fearless Floyd. Boom, 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 boom. FearlessFloydShow.com, Fearless Floyd Show at yahoo.com. If you want to reach me, I'm on these social media platforms over here, among others. Got some classes going on. Like, subscribe, share, hit the notification bell. The reason I want you to hit the like button, because I don't care whether you like the video, like me, like the content, like my guest, co-host, whatever. It's for an algorithm. So when you hit the like, you will see other videos like this video. That's the whole reason. So it's not for a popularity contest. So please hit the like button. That way you'll get more content like this on these topics. All right. It is, I don't know if I said it's January 27th, 2023, Friday, and it is a gorgeous, beautiful day. It is 54 degrees. It says cloudy, but man, I don't see a cloud in the sky, to be honest with you. I've already been out there. It's just gorgeous. So here in Plano, Texas, I will be live at 2 o'clock, or actually noon, 12 o'clock till 5 at Sky Pony Gallery. Um, I can't give you the address off the top of my head, but it's on West Park in Plano, Texas. Autograph session starts at 5. I will not be giving, or well, if you ask for one, I'll give you one, but it's for Wano Saban. It's his autograph party, not mine. Uh, Chris Eriks was kind enough to invite me, so we'll see how that goes. All right, let me dive into this before we get going too far along. All right, and this is their petitioner's petition for rehearing. Okay, this is the Supreme Court case number in the Supreme Court of the United States, Raylan J. Brunson petitioner versus Alma S. Adams et al., which means there's more than one defendant, which we already know. They are the respondents in this particular case on petition for writ of certiorari to the United States Court of Appeals for the 10th Circuit. So what they are doing is they're asking for a certiorari review, which was on a blanket denial order. And so they filed this petition for rehearing. And this is Raylan Brunson. This is counsel for respondents, which is Solicitor General. Table of contents, table of authorities, points of authorities, arguments, supportive rule for rehearing, argument. Why should this honorable court grant rehearing? Oath of office. How important is the oath of office? We must investigate to identify the enemy. Allegations of war should be investigated. To petition for redress of grievances. Broad powers of the Supreme Court. Can a U.S. congressional session become an administrative act under fraud? The doctrine of equitable maxim. Conclusion. Certificate of good faith pursuant to Supreme Court Rule 44. Table of authorities, constitutional provisions, Amendment 12, Article 6, Clause 3, cases. Well, that's actually not a case, that's a code. So, yeah, that should be separated, but that's all right. Title 18 USC, Section 2381, U.S. versus Burr, 1807, Fourth Branch, 8 U.S. And here's the lawyer's edition that I tell you guys to just totally ignore. Okay, this is a very, very, very early volume of the United States Supreme Court case. Of course, you can see it's from 1807, and then we have the rules, Supreme Court Rule 171444.2. Points, authorities, and arguments. Supportive rule for rehearing. Rehearing of the denial of certiorari is appropriate in situations involving, quote, intervening circumstances of substantial or controlling effect or other substantial grounds not previously presented. Close quote, Supreme Court Rule 44.2. Because this is such a case, petitioner moves this honorable court to grant this petition for rehearing. Now, on my personal opinion, they have a good argument, but I just, if they didn't take it the first time, I really just don't see them taking it the second time unless they see the error of their ways. But I just don't see the American people, standing up in a big revolt and petitioning in front of the Supreme Court building and, just raising hell, basically. Oh, I did not share my screen, did I? Get back over here. Don't. Sorry. I'll scroll back up so you guys can just see what I read, rather, what I read. It was received the 26th. There's your table of contents, which I already read. Now I'm getting into the argument. Why should this honorable court grant rehearing? This honorable court is needed to resolve serious conflicts that are plaguing should be America. There's some couple little mistakes in here. So if the Brunson Brothers, if you are watching this, hey man, you can run your vehicles past me. I will edit them for you guys for free. Absolutely. Okay, this case represents a very powerful domestic cover operation that is so benign that it cannot be seen on how it has breached our national security and how it is affecting the national security of both Canada and Mexico, and how it has circulated fears that we might soon see the destruction of property along with a large volume of bloodshed in our own streets, all stemming from the fact that our courts have not declared that the oath of office is binding with penalties. Now, that right there, that last sentence, boom, okay? That should have been your argument. And I don't believe you argued it in your certiorari. Not that specific. You didn't make that a point of fact or a point of contention or a point of argument. That's okay, though. The oath of office. How important is the oath of office? The U.S. Constitution, under Article 6, Clause 3, states that, quote, states that the oath, quote, shall be bound by oath or affirmation, close quote. If there is no penalty for violating the oath, then there is not a binding. How can Congress take an oath to uphold the Constitution, then pass laws that allow Congress to be immune from suit from intentionally violating the Constitution up to and including treason? Currently, because of this, members of Congress, with their power to assemble and with their voting powers, can completely redo the Supreme Court of the United States to their liking, like packing the court. I wouldn't have used the term redo. I would use restructure. So get you a Burton's thesaurus and get you a regular, or Burton's legal thesaurus and get you a regular thesaurus and start utilizing different words. And I know you guys were under a timeline, but hey, sometimes you have to reach out to people and get volunteers and people who've written hundreds of legal vehicles, as I have. I've written thousands. I mean, it's just crazy. Quote, I want to tell you, Gorsuch, and they're speaking to Justice Gorsuch of the United States Supreme Court. I want to tell you, Kavanaugh, Justice Kavanaugh of the United States Supreme Court, you have released the whirlwind and you will pay the price. You don't know what hit you if you go forward with these awful decisions, close quote. Chuck Schumer, which is the New York State Senator, or I'm sorry, he is the New York State Federal Senator, told a cheering crowd in March of 2020. This statement can easily be found on the internet. You guys should have put a footnote right here. And then at the bottom, y'all should have put the link where it can be found. Absolutely. Title 18, U.S. Code. Y'all missed a period and you missed the C and a period, but no big deal. 2381 states that whoever owing such allegiance violates this allegiance shall be incapable of holding office. What we see is that whoever violates this allegiance can still hold office even though they are incapable of holding this office. Isn't this a serious conflict? Well, it's an oxymoronic policy, whatever it is. Number 2, you must investigate to identify the enemy. When members of the United States, or members of U.S. Congress make a request to the body of Congress to investigate an enemy to the Constitution that is hiding under Amendment 12, and under the guise of, quote, honest election, close quote, then wouldn't it be the duty under their oath to investigate these claims? How can you know if an enemy exists if you don't investigate? I would have put do not. How to speak clear and concise. Don't abbreviate. Allegations of war should be investigated. Allegations that claim the election is rigged should be investigated. If one of the purposes of war is to put into power its victor, and since a rigged election accomplishes the same thing, which is to put into power its victor, then isn't a rigged election an act of war? This honorable court has already ruled that one need not pick up arms in order to, quote, levy war, close quote, in U.S. versus Burr, 1807 Fort Ranch, which I've already discussed. The oath of office requires that aid and comfort cannot be given to those levying war through a rigged election. The presidential rigged election is a threat to the Constitution, and therefore, when members of Congress become aware of such allegations, an investigation into these allegations is required, or they become violators of their oath of office. If a person who takes the oath of office owes allegiance to the United States, and if under Title 18 United States Code Section 2381, it states that whoever owing such allegiance violates this allegiance shall be incapable of holding office, then wouldn't it be fitting that they shall be removed from office as well? Obviously, the allegiance to the United States requires the necessary steps to defend the Constitution of the United States against all enemies, foreign and domestic. Isn't it proper and fitting that any interpretation of the Constitution that is used to give aid and comfort to such enemy is nullified? During the 117th session of Congress, a request was made to investigate the allegations that the 2020 presidential election was rigged. How can Congress use Amendment 12 as an excuse to vote against investigating these allegations? The petition for redress of grievances. The complaint of this case seeks redress of grievances against the respondents. Nowhere is it written that Brunson cannot do this under the First Amendment and bring his action either in state or federal courts. The right to seek redress of grievances is protected, and they didn't put in all states as well as the federal Constitution. Absolutely. And in the International Declaration of Human Rights. Whether y'all know that or not, I don't know whether y'all have read that. Number 5, broad powers of the Supreme Court. The Supreme Court holds all the same powers of lower courts, and it is the Supreme Court in the land. Pursuant to Supreme Court Rule 17, this court has original jurisdiction. Therefore, under the unique circumstances of this case, can't this honorable court fully adjudicate this case? That's a lot of... When a case like this one comes forward under a petition for writ of certiorari claiming that there exists a serious national security breach and that this breach is an act of war and that it requires an act on an emergency level to repair this breach immediately to stop this war, and that these perpetrators of this breach are the respondents, doesn't this court have the power to adjudicate these serious claims and to immediately end the conflict and fix the national security breach? The court can do a lot of things. Are they going to do it? That's a good question. Quote, we the people, close quote, have declared that the Constitution was established to secure the, quote, blessings of liberty, close quote, and have joined with Brunson on a large scale with their souls and prayers that this court will grant this petition. Google, quote, Rayland Brunson, close quote, or quote, Brunson case, close quote, and see how much this case brings hope across the globe. Facebook, YouTube, Twitter, and other social giant platforms work vigorously to keep this case from becoming popular. References, footnotes, guys, come on. Don't make any claims without backing up your allegations 100% with fact. Give me a Facebook reference, give me a YouTube reference, give me a Twitter reference, and other social platforms, okay? even if it's an affidavit in support from somebody who has Facebook that has firsthand knowledge. Can a U.S. congressional session become an administrative act under fraud? On page APP 58 of Brunson's writ under the heading subject matter jurisdiction and with the support of the proper legalese, Brunson points out with the proper legalese that fraud vitiates everything it touches and that the purpose of the 117th session of Congress was to count the votes under the 12th Amendment. And but because they refused to investigate the allegations that the election was rigged, which is an act of fraud, and being that the 12th Amendment cannot protect fraud, therefore, didn't the said session of Congress turn into an administrative function, making them all liable for suit without the protection of any kind of judicial, jurisdictional, or any kind of immunity? The doctrine of equitable maxim. The doctrine of equitable maxim kills the doctrine of the object principle of justice. Under case number 18-1147, it states that equitable maxim seriously conflicts with the object principle of justice and provides all the legalese in support of this statement. Both doctrines influenced and or created by this honorable court. Well, I would have liked to have seen those spelled out. Should this court decide to overturn equitable maximum in favor of object principle of justice, obviously it would do this because it believes in doing so, in doing our courts, in so doing, our courts would no longer be precarious. Trial cases would be much easier with less stress to judge. Settlements would grow much higher, less lawsuits would be filed, appeals would be greatly reduced, and our court system would be the most just and highly respected and dearly admired court system more than ever before. Oh, flattery will get you nowhere, guys. Tried it. Due to the serious nature of this case, a breach of national security arising from an act of war as described above, petitioner moves his court without delay to single-handedly exercise its power to correct this breach and to bring peace and hope back to this land by granting this petition in its fullest request. Dated January 18th, 2023, respectfully submitted, Raylan J. Brunson, petitioner in pro se. Could be pro per, is coming proper. Raylan J. Brunson. And certificate of good faith pursuant to Rule 44, petitioner to his best of his ability hereby certifies that this petition for rehearing complies with the restrictions of this rule and is presented in good faith and not for delay. January 18th, respectfully submitted, Raylan J. Brunson. So yeah, I would have made this a little bit different, but that's fine. You know, I don't know how much experience these guys have filing into the United States Supreme Court or drafting legal vehicles or drafting them on the fly in such a short time and having to deal with all the media attention, interviews, phone calls, emails, U.S. mail. So, thank God there's 4 of them and they're all working together. So, here it is from Fearless Floyd. Hey, bro, if any one of you guys need some help or anything, man, just reach out to me, fearlessfloydshow@yahoo.com. You can reach me easily. Thank you for doing this, guys. I really appreciate it. Like I said, I'm going to try to get you on the show for interview. Try for next week or the week after. Get all 4 of you on here. I don't know. I'll see what that looks like. I was trying to catch up with y'all Tuesday in Austin. Couldn't make it. Got to do my own gig. All right. I got to close for now. It's 11:34. I'll be going live here in a minute. So with that, like, subscribe, share, hit the notification bell, leave a comment below. I got some classes coming up. I'm over on these social media platforms. This space is for rent. I have a sponsor, I believe, coming on board. So we'll look forward to that. Fearless Floyd Show .com. Go to the website. Check us out. Appreciate you being here. Love you guys. I'll see you in a minute. Live.